Everyone. Welcome to the Environmental Law Institute's monthly climate change briefing for the month of November. I'm Madison Calhoun, ALI's educational programming attorney. Staying on top of the legal and policy developments in the climate change arena is no small task. The Environmental Law Institute provides a series of monthly webinars with national experts on climate law and policy to keep you up to date with short presentations about various sectors. Before we get started, I want to thank you all for joining us today, as well as our fabulous speakers for taking the time out of their busy schedules to prepare updates and share them with us. We hope to save a couple of minutes at the end of today's program for questions. If audience members have any questions during today's event, please submit them using Zoom's Q&A feature at the bottom of your screen. You can submit your questions as soon as you think of them. There's no need to wait until the end. We also have opened up the chat in case you would like to post any observations throughout the event. Please remember to use the Q&A function, not the chat, for any questions you would like our speakers to address, though. And now I will go ahead and hand things over to our first speaker today, Michael Gerard. Michael's the founder and faculty director of the Sabin Center for Climate Change Law at Columbia Law School. He'll be providing several litigation updates today. So over to you, Michael. Thank you so much.
Thanks very much, Madison. So a group of heavy-duty truck and engine manufacturers filed a motion with the Eastern District of California Federal Court for a preliminary injunction enjoining the California Air Resources Board, CARB, from implementing the Clean Truck Partnership. That was a 2023 agreement in which CARB agreed to undertake certain regulatory actions sought by the manufacturers, and the manufacturers agreed to meet certain state clean vehicle standards. The court granted the preliminary injunction sought by these companies. It found that the manufacturers showed that there were clear questions going to the merits of their claim, that the Clean Air Act preempts the Clean Truck Partnership, and that CARB's filing of a breach of contract lawsuit on October 27 to enforce the agreement was sufficient to establish concrete and non-speculative irreparable harm. The court also found that the balance of equities tipped in favor of the manufacturers. That case is Daimler Truck North America versus CARB. New York State had adopted a law banning natural gas appliances and infrastructure in certain new buildings. The law was challenged on the grounds that it was preempted by the Energy Policy and Conservation Act. The U.S. District Court for the Northern District of New York ruled that the law was not preempted. The plaintiffs filed a notice of appeal with the Second Circuit, and last week the plaintiff and the state of New York filed a stipulation staying the effective date of the law until 120 days after the Second Circuit decides, and if there's a cert petition, until 120 days after the Supreme Court rules on the cert petition. Environmental groups are very unhappy about this development, and there's this issue may now get back to court. We'll see. The New Mexico Supreme Court granted a petition for a writ of certiorari brought by the plaintiff seeking review of an intermediate appellate court's decision ordering dismissal of the plaintiff's claims under the New Mexico Constitution that the state system for regulating pollution from oil and natural gas violated the rights of the plaintiffs. The state Supreme Court said it would review, among other things, whether the appellate court fundamentally misapprehended its duty to enforce positive constitutional rights, wrongly ignored constitutional jurisprudence from New Mexico and other states, and effectively erased the pollution control clause of the Constitution by finding plaintiffs' claims under the clause non-justiciable and beyond judicial review. The Fifth Circuit rejected a challenge to the authorization of a project to expand the capacity at 3 compressor stations on a natural gas pipeline serving the Pacific Northwest. Under NEPA, the Fifth Circuit concluded that FERC did not act arbitrarily and capriciously by adapting its environmental impact statement and approving the expansion project. The court cited the deference due to FERC's NEPA review under the Supreme Court's decision in 7-County Infrastructure Coalition versus Eagle County, a case we've talked about several times. And the court rejected the contentions of the environmental organizations that FERC failed to consider the impacts of a no-action alternative and other alleged defects in the environmental impact statement. A New York trial court ordered the State Department of Environmental Conservation to promulgate regulations implementing the Climate Leadership and Community Protection Act. The court concluded that that statute mandated that the department issue regulations by January 1, 2024 to ensure compliance with the law's emissions reductions mandates, and that DEC did not have discretion not to follow the legislative mandate. The state has indicated that it will appeal this decision, which gives them an automatic stay of the order. The Federal District Court for the Western District of Washington remanded a climate change-related wrongful death action to state court. The plaintiff is seeking to hold fossil fuel companies liable under product liability and public nuisance theories for her mother's death during the Pacific Northwest heat dome event of 2021. The court rejected the position of the defendants that there was federal diversity jurisdiction because none of the defendants, a company that owned a pipeline, had been fraudulently joined. The court was satisfied that the pipeline owner was a citizen of Washington. Finally, the New York Attorney General and JBS USA Food Company settled a lawsuit by the Attorney General that alleged that the Net Zero by 2040 advertising campaign of JBS, a meat products producer, was false and misleading in violation of the state consumer protection laws. After a New York trial court dismissed the case without prejudice in January of this year, the Attorney General issued an investigative subpoena and prepared but did not yet file an amended complaint supported by additional evidence. JBS agreed to remove or revise existing U.S. consumer-facing published statements that concern net zero by 2040, presenting it as a goal rather than a pledge. And JBS also agreed to pay $1.1 million to Cornell University's College of Agriculture and Life Sciences to support climate-smart agriculture. So that's my litigation report.
Thank you so much for those updates, Michael. Up next is Ebony Guerrier, who is counsel at Singleton Schreiber. Ebony typically joins us every other month to provide an environmental justice update, and she'll be providing an update today on Inclusive Louisiana v. St. James Parish. So over to you, Ebony. Thank you so much.
Thank you, Madison. Good afternoon, everyone. So just a few weeks ago, the United States Supreme Court denied cert in St. James Parish versus Inclusive Louisiana, letting stand a unanimous Fifth Circuit decision that could reshape environmental justice litigation nationwide. So what this means is that after 2 years of procedural battles, Cancer Alley residents will finally get a trial on the merits of their claims that decades of discriminatory industrial siting violates their constitutional and civil rights. St. James Parish, it sits in the heart of Louisiana's Cancer Alley. And Cancer Alley is an 85-mile stretch along the Mississippi River. It sits between Baton Rouge and New Orleans, and it's home to over 200 petrochemical facilities. It's the largest concentration of petrochem facilities in the Western Hemisphere. And the area's name isn't hyperbole. Residents there face some of the highest cancer risks from industrial air pollution in the entire United States. Unfortunately, that burden isn't shared equally. Since 1958, at least 20 of the 24 industrial plants built in St. James Parish have been sited in Districts 4 and 5. Districts 4 and 5 are the two districts with the highest Black populations at 89% and 52% respectively. By contrast, no new industrial facilities have been permitted in the majority white districts in 46 years. Plaintiff appellants, which include 2 faith and community-based organizations and a church located in St. James Parish, Louisiana, sued St. James Parish Council, and the St. James Parish Planning Commission, bringing 7 claims for violations of their constitutional and statutory civil rights. So those claims include 13th Amendment badges and incidents of slavery claims, 14th Amendment equal protection claims, 14th Amendment due process bodily integrity claims, 42 U.S.C. 1982 property rights claims, substantial burden and discrimination claims under the Religious Land Use and Institutionalized Persons Act, and also Louisiana constitutional claims regarding preservation of cultural origins. So the plaintiff organizations alleged that the parish discriminates against them by directing hazardous industrial facility development towards majority Black districts and Black churches. They also argued that the parish authorizes industrial development that desecrates, destroys, and restricts access to the cemeteries of their enslaved ancestors. The plaintiffs allege a continuous pattern of racially discriminatory land use decisions spanning decades, not just a single discrete act. And as an example of one of these discriminatory land use decisions, in August 2022, the parish rejected Black residents' request for a moratorium on polluting industry in their communities. But the same day, the parish granted white residents' request for a moratorium on solar farms. So in November of 2023, District Court Judge Carl Barbier dismissed all of the claims. He held that most claims were time barred by the 1-year statute of limitations because they arose from the 2014 land use plan. He also dismissed religious injury claims for lack of standing, holding that the injuries were not fairly traceable to the parish, and he found only limited standing for some property injury claims. On appeal, a unanimous 3-judge panel reversed and remanded, specifically holding that the claims were not time barred. They found that the 2014 plan wasn't a single discrete act, but that it was part of a long-standing discriminatory pattern with recent acts, including the 2022 moratorium decisions, and that those acts fall squarely within the limitations period. And they also held that the plaintiffs established standing, finding that the plaintiffs adequately alleged concrete traceable harm from toxic exposure, diminished property values from discriminatory siting, personal subjection to unequal treatment based on race or stigmatic injuries, and that the parish's land use decisions enabled the desecration, then that was sufficient for traceability. Critically, the court also found that the land use plan itself isn't self-implementing, meaning that each individual permit decision is a separate governmental act that can give rise to new claims. And that's it for me. Thank you.
Thank you so much, Ebony. Up next is Dan Farber, the Shovsado Professor of Law at the University of California, Berkeley. Dan will be providing updates about California's role at the COP30 and about other developments in California and other states. So I'll turn things over to you, Dan. Thank you.
Thanks, Madison. So let me start with California at the COP, which Madison mentioned. On day 3 at COP30, Governor Gavin Newsom oversaw California's entry into a series of new international partnerships with Colombia, Chile, and Brazil, strengthening California's leadership. This is the California perspective in the global fight against climate change. These partnerships are intended, according to the parties, to boost innovation, improve environmental protection, and strengthen cooperation on climate and job-creating clean energy. The biggest impact, however, may not be the substance of these agreements, but rather an effort by California to demonstrate that despite President Trump, Americans and parts of American government are still engaged on the issue of climate change and are looking to work with other countries on the issues. So this is an effort to fill the gap due to the federal government's withdrawal from any role in the international negotiations. In the third quarter of 2025, getting back to more mundane matters, ZEV, zero-emission vehicles, accounted for 30% of all new car sales in California, a record. In a related development, the California Climate Energy Commission made California the first state in the country to adopt EV charger reliability and reporting standards. Given the vacuum in terms of federal involvement, California may help establish a de facto national standard, taking advantage of its role as first mover. Moving to other states, in Illinois, at the end of last month, Illinois legislators passed the Clean and Reliable Grid Affordability Act. The bill, which is now on the governor's desk, aims to strengthen Illinois' energy grid and protect communities from rising energy costs using energy storage incentives and new utility requirements. Also, the Illinois Commerce Commission approved key updates to the Illinois Power Agency's long-term renewable resources procurement plan with the goal of expanding solar capacity and protecting Illinois consumers from rising energy costs. This illustrates something I talked about last month, which is the growing attention among regulators and legislatures to the issue of affordability as consumers are faced by rising electricity bills. In Colorado, state officials are seeking to extend the life of a major coal generating unit in order to prevent spikes in electricity rates, again, demonstrating the affordability theme. The unit was scheduled to close at the end of this year, but officials are now seeking a one-year extension after another turbine at the same facility suffered extensive damage. So this is a stopgap to take the place of the other turbine. This is a reminder that although fossil fuel plants are not subject to the same types of intermittency as solar or wind, that doesn't mean that they run 24 hours, 365 days a year. And in some cases that their generation failures may not be easily foreseeable. Back to the West Coast in Oregon, an executive order fast-tracks renewable energy projects to help developers qualify for federal tax credits. Federal tax credits are on a phase out, and the executive order directs state agencies to take any and all steps necessary and authorized by existing statutes to prioritize siting and permitting for renewable commercial projects in order to enable them to begin construction by July 4, 2026, which is a critical deadline under the phase out for tax credits. Under the governor's order, the Oregon Public Utility Commission will accelerate procurement of renewable energy resources. And the governor also directed the commission to consider using an outside contractor to study how solar and wind power projects connect to the grid, with the goal of speeding up that process. And then in one final development at the state level, the governor signed a bill to exit RGGI. That's the northeastern state carbon trading system in order to increase, according to the governor, energy affordability. The state's other major climate initiatives had depended on funds from the Inflation Reduction Act passed under President Biden, but largely rolled back under Trump. However, the exit from RGGI may not be as much of a rollback as it might seem, because the state's effort to join RGGI had never actually gone into effect. There was litigation regarding that effort. The litigation is still, or was still pending until the passage of the new statute. So at ground level, the situation is the same as ever in that Pennsylvania has not been and now will not be a member of RGGI. However, this is obviously a setback for climate advocates, particularly given the failure of the state to take other initiatives in the post-Biden era. And that's it for me.
Thank you so much, Dan. And last but not least, we have Bob Sussman, principal at Sussman and Associates, who's joining us to provide an additional update about the COP30, as well as an update about EPA's proposal to repeal greenhouse gas reporting requirements. So over to you, Bob. Thank you so much.
Yeah, thanks, Madison, and hello to everybody out there. I want to start with the discussion of the greenhouse gas reporting program and then comment on COP30. One of the most interesting developments in the current climate policy world is the strong and surprisingly diverse pushback EPA is getting on its September 16 proposal to sunset its greenhouse gas reporting program. Under the proposal, reporting of greenhouse gas emissions data would be terminated permanently for most emission sources and suspended for 10 years for a small number of additional sources based on a determination that EPA lacks statutory authority to require reporting. This is a new legal position for EPA and likely grows out of a belief that greenhouse gas reporting is no longer necessary or useful, given the administration's overall retreat from using EPA's regulatory authority to address climate change. To provide the larger context here, the origin of this reporting program was actually appropriations legislation enacted by Congress in 2008, which directed EPA to develop and publish a rule that would require mandatory reporting of greenhouse gas emissions in all sectors of the economy of the U.S. In the accompanying joint explanatory statement for the act, Congress directed EPA to, quote, use its existing authority under the Clean Air Act to promulgate the rule that would establish the program. And EPA then did that in December 2009, relying on its information gathering authority in Section 114A of the Clean Air Act. However, EPA now believes that the Clean Air Act authority doesn't apply because reporting is not directly connected to any of its programs under the Clean Air Act. Not surprisingly, the states and environmental groups are challenging EPA's position and asserting that the reporting program is not only authorized but required by Congress. The surprising thing, though, is that several industry groups have also weighed in to support the benefits of greenhouse gas reporting to American business and urge EPA to continue the reporting program either in its current mandatory form or on an environmental basis. And the groups speaking out here are real industry heavyweights such as API, the American Petroleum Institute, the Edison Electric Institute, the National Association of Manufacturers, and others. One of the most interesting industry arguments is that if the U.S. wishes to continue to tout its energy industry as the cleanest in the world, credible and reliable reporting of greenhouse gas emissions will be necessary to make the U.S. case. Another argument is that without a uniform and centralized federal reporting program, there will be a patchwork of voluntary or state-based reporting programs, and this will result in fragmented, expensive, and non-standardized third-party verification procedures that ultimately make it very difficult to compare emission levels across companies and sectors, and would also increase reporting costs. Yet a third concern is that without reliable emissions data, U.S. exporters would be at a competitive disadvantage under non-U.S. programs like the European Union's Carbon Border Adjustment Mechanism that adjust tariffs and other trade protections based on the carbon intensity of imported products. Now, in another unusual aspect of this situation, uh, Senator Whitehouse, who is a Democrat and chairman of the EPW committee, and Senator Kramer, a Republican, have joined in a letter to the administration urging it to withdraw EPA's proposal because it would undercut the competitiveness of U.S. industry. This type of negative feedback from industry mainstays is relatively unusual for an administration that has set out to reduce regulatory burdens as part of its much ballyhooed energy dominance agenda and rejection of climate change as a hoax. It's going to be very interesting to see whether the administration stands its ground here or backs off. So stay tuned. Just a couple of observations about the COP. This has been a pretty downbeat event compared to previous COPs. One reason is the relatively modest attendance of heads of state and celebrities, which has dampened media coverage. The Trump administration did not send any representatives to the COP. And of course, this was a striking contrast to the extensive U.S. presence at COPs during the Obama and Biden administrations. The only representative from the federal government at the COP was Senator Whitehouse, who we just mentioned, and he severely took the Trump administration to task and also warned that the world is on the wrong track on climate change. The backdrop for the COP was a widespread recognition that there are large gaps between companies, or rather countries' national commitments to reduce reductions and their actual performance on the ground. So I'll stop there and would just reiterate that this is so far not one of the great COPs that has moved the needle on climate change, although we don't yet know what actions the parties at the COP will ultimately adopt, and some actually may be fairly promising. So stay tuned there. And that's my report.
Thank you so much, Bob. We are just about out of time, but I did want to leave a moment to open up the floor to see if our speakers have any comments on any of the topics that were discussed, any questions for one another, or any quick responses to questions that came into the Q&A.
I had a question for Michael about the California Clean Truck ruling. I'd just be very interested in your assessment of the ruling and whether it's likely to hold up on appeal.
I dare not give a prediction on that. That's really hard to say. We're certainly seeing any number of actions on clean energy being challenged on preemption grounds, whether under the Clean Air Act or the Energy Policy and Conservation Act. We're seeing quite a few of those preemption actions, but none of them have gotten to the Supreme Court, and we'll see. Too early to say how they're going to turn out.
Thanks.
Thank you all so much for joining us for November's monthly climate change briefing. I so appreciate your time and engagement. Additionally, thank you to Michael, Ebony, Dan, and Bob for their great updates. Please join us back here on December 16th for our last briefing of the year. There was a question in the chat about the recording. So this program was recorded and the recording will be posted to the ELI website for ELI members to view later. Programs like our climate briefings are made possible with the support of ELI members. Members can attend exclusive member webinars, and they have access to many other benefits such as our webinar archive, our weekly newsletter, our acclaimed publications, and so much more. If you're not already an ELI member, we encourage you to visit us at eli.org to join. Thank you all once again, and we hope you have a wonderful day.